I think 4 times you have changed your
Yes,
prayers.
yes. From 2023 to 2025, we have been languishing in the court. Governor thought that we are remediless. We will go out of the court, we will be ousted out of the court without any reliefs. But I have to thank the Constitutional Court, it has stood up. Can you say that I will withhold the bill? This is actually a life. This is a will of the people. What is a bill? A bill is a people's expression.
Hello everyone. In landmark move, for the first time, Supreme Court has laid a time frame for the governor to give a assent on bills passed by the assembly. Joining by me, senior DMK MP as well as senior advocate P. Wilson, who argued this case in the Supreme Court. Thank you for joining with us, sir.
Thank you, Vanakkam.
Vanakkam, sir. Sir, what are the main points that Supreme Court has indicate that governor has follow the timeline? What are the main points you want to highlight, sir, in this case?
So, if you see the main points, highlights of this judgment is the court has clearly spelled out the powers of the governor under Article 200. I would say it has summed up the powers by quoting various judgments, right from Shamsher Singh case and Rabam Nabia's case. All the judgments have been taken into
Previous
consideration.
judgments related to governor's power.
Exactly, related to the governor's powers, functions, duties, responsibilities, particularly with regard to the Article 200, because the court was dealing with Article 200. And ultimately, I said that what are the options available to the governor while dealing with the bill? They have said at the first instance, when the bill is passed by the Legislative Assembly and sent to the assent of the governor, then the governor has got only three options. First option is that he has to, he can give his assent. Second option is he can withhold the assent. The third option is that he can forward it to the consideration of the President of India. So these three options are available before the governor. If the governor decides to withhold the assent, then he has to necessarily send back those information to the assembly. And when the assembly reenacts it and send back to the governor,
Again,
then he has no other option than to give assent. The only way the governor can forward to the president is in his discretion. All these three functions which I told you earlier, that is to grant assent, to withhold assent, or to forward the assent, it should be on the aid and advice of the Council of Ministers.
okay.
The governor has no independent veto. He has no pocket veto in the sense that he cannot act independently.
The council who represented governor, he said the governor has rights to reject or delay the bill. How you counter this point?
Even for forwarding to the president at the first instance, he has to, act under the aid and advice of the Council of Ministers. The only exception that he has got at the second time when he wants to forward it to the president is that this bill should not fall within the five sections where the only authority who can give assent is the president. So, the court itself has clearly said which all the provisions when they have legislated the bills on these provisions, then they have to send it to the president. So, if it is not within that provisions, he had no power even to send it to the president. So, therefore, the court held that all action of the governor when the bills was reenacted and resent to him for a second time, namely the actions of the governor in forwarding to the president and the president, withholding assents are held to be illegal, unconstitutional, and it was, held to be ultra vires of the constitution. And ultimately, the court has said that considering that these 10 bills have been delayed for without any reasons, without any justification, an inordinate delay is there. So the court said that it is deemed to have been granted assent because
Okay.
it's for the second time it has come before him after reenactment, and this is the order passed under Article 142, which is the ultimate justice to be done for the parties before the court.
What are the challenges you faced during this hearing, sir? Because it's not that easy to get such order.
The first challenge was there were a lot of doubts raised even during the discussion stage and even when we filed the writ petition. Of course, I was very firm about the case, about the merits of the case, and the powers of the Constitutional Court. So I was very firm that Supreme Court will render justice in the given facts and circumstances of the case. The second challenge was from the governor himself. When we filed the writ petition, it was somewhere in November. When the case came before the Supreme Court in 2023, the bills were sent at the first instance and pending before him. So the governor, the prayer was in a writ petition is to direct the governor to
Give assent.
take a decision. And there were other prayers also in the writ petition. So therefore, with these prayers, we went to the Supreme Court. And when the bills, it was pending before him, even without giving assent to for about 3 years.
Oh,
The bills, even before our Honorable Chief Minister came to power,
wow.
the bills passed by the DMK government, even with regard to the change of the name as Jayalalitha, former Chief Minister name university, that also was pending with him. So when we went to the court, the bills were pending before him, sent for the first time. What happened when the Supreme Court issued notice? He immediately withheld his assent. So he wanted to make our writ prayer infructuous. That was a challenge to us. So the bills were withheld. He did not return back the original bills. Somehow, someone would have advised him not returning back the original bills will amount to a bills dying off by itself after withhold by the governor. But he sent a file making a note that he is withholding the bill. Along with that, he sent one Xerox copy in which he has already written, and that is also a Xerox copy. The Tamil Nadu Legislative Assembly, so I should appreciate our Honorable Chief Minister. The Tamil Nadu Legislative Assembly was convened and the bills was reenacted and resent to him. They wisely invoked Article 200. If second time the bill is sent,
First.
he will be cornered. The Honorable
Correct.
Governor will be cornered.
Only one option.
Only one door is open to him, that is he has to give assent. But what he did is, this is a second challenge we faced before him. He immediately sent the bills to the president. He did it on his own. So now we can't, what could be a prayer now? So again we have to amend the prayer.
Correct.
So second time when the bills were sent, we amended the prayer. Third time what he did is when he sent to the president, we have to amend the prayer, restrain them, send back all the bills to him. After that what he did is, when the cases were pending, of course, when the matters came up, they used to take an adjournment on some pretext or other. And after that the case was not listed. Of course, we had some problems like Ponmudi, Honorable Minister, he did not
Take oath as a
gave, yes,
minister.
gave any time or thing for
Appointment
yes,
for getting.
for carrying out that function. So therefore, that oath ceremony function, you call it as oath ceremony function. So therefore, for that also we had to move the court by way of a miscellaneous application, and the court asked the governor, when Podmudi lost his, was disqualified because of the judgment of the High Court, holding him guilty of certain offences, and that High Court judgment has been stayed by the Supreme Court. What is the difficulty you doing this oath ceremony? But the governor blatantly refused. So therefore, the Supreme Court said, I will give you tomorrow 24 hours time. If you don't perform this oath ceremony, then we will do our work. We know how to do it. And then the next day, he called the minister, and
Ceremony was
ceremony
conducted.
was conducted. Now, so far as the governor sending the bills to the president, what he did is he wrote a letter, even without the aid and advice of the Council of Ministers, independently asking the president to reject the bills.
Okay. Is there any provisions given by the?
Where is the power?
Okay. In the constitution, there is no.
Where is the power? He can't act independently. Who has given him the power? So he wrote a letter to the president, and the president, of course, is advised by the Council of Ministers at the union level. And the 7 bills were rejected. Out of 10 bills, 7 was rejected. 2, we do not know the fate at all. Till today, it is still lying in the cupboards. One, bill was passed. So again, we have to come to the court and say, look, these are all the subsequent events. So we have to modify and then say all actions are illegal and unconstitutional against Article 200. At one point of time, when there was no meeting of minds between the governor and Honorable Chief Minister, the Supreme Court Chief Justice said, why it instructed the
to sit
Attorney
together.
General,
Yeah.
why not the governor call the elected Chief Minister to your Raj Bhavan,
Correct.
and with a cup of tea, why don't you sort out the differences?
Correct.
So that also the court said that you have to do it. The governor didn't do it immediately. But what he did is, on the next hearing, when the case was listed, that time he sent a letter saying that please come. That was in somewhere in December 2023.
Okay.
Then we had some flood problems and other things, and also the chief minister responded, and he met him in January 2024.
Correct.
So that was the attitude the governor was having towards the elected government. And so therefore, at every juncture, it was a challenge for us. That apart, what will happen now? The president has rejected. So probably governor thought that we are remediless.
Okay.
He thought that we are remediless.
Correct.
We will go out of the court, we will be ousted out of the court without any reliefs. But I have to thank the Constitutional Court, it has stood up. After holding that every actions of the governor is illegal, ultra vires of the Constitution, and even went to the extent of saying his conduct, the court has indicted governor on his conduct. Ultimately, I said that, look, all the 10 bills deemed to have been granted assent. Now, because of this order, all the actions of the governor, starting from referring it to the president, and the president of India withholding 7 bills and 2 bills, sleeping in the shelves, and 1 bill assented to, all becomes, unconstitutional, illegal. Those orders have been set aside, and now it is going status quo ante. It is restored back to the original second time when the bills came to him, to that status, and the court has granted granted a declaration saying that the bills have deemed to be granted assent. Therefore, today
That court has that power, sir.
it is a constitutional court. That is what I have to explain to you, the powers of the constitutional court. So I will finish this aspect with regard to the court's declaration. Once this declaration is given, It's enough that the government publishes the court's order. There, the law will come into force. It's the first time in the history of India it has happened. And you were asking me one pertinent question. So, therefore, the powers, once the constitutional court comes to a conclusion that what all the actions done by an authority is illegal, it is not powerless.
Okay. The governor R.N. Ravi's lawyer emphasized on the discretionary power of the governor and argued it's allowed him to delay or reject the bill. How did you counter this position, sir?
One of these arguments made on behalf of the governor is there is no time limit. The constitution trusted the constitutional authorities, namely the governor under Article 200, that he will act as soon as possible. Probably the present governor has lost the sight of the word as soon as possible appearing in Article 200. Earlier, we had a Government of India Act 1935 that was replaced with the Constitution. In 1935 Act itself, we have time limit. There was a time limit in the Government of India Act, but what the constitutional makers thought when they deliberated the powers of the president as well as the governor is, why should we give time limit of 30 days or 90 days? They have to act immediately because it is a bill.
It's urgency.
There is an urgency. So therefore, they said if we give the time, the file will be kept unnecessarily in the president office saying that we have a maximum time limit of 30 days or 90 days. That is why they consciously use the word as soon as possible, and that is why they did not prescribe the time limit. Now, take the current case. The governor has slept over 3 years. There is only a 5-year term for any elected government. So, for 3 years, we are waiting on the doorsteps of governor. He doesn't do anything. Then we come to the court, and another 2 years we spend litigating in the court. So, all the 5 years will be in the court and in the governor's doorsteps. That is not the thing of the constitution. So, that is why there is a clear sharing of the power. There are separation of powers. If one wing fails to act, the other wing will raise. So, he had taken more than 3 years, and the pendency of the court is also there. So, therefore, that is why the court thought, let us fix a time limit. This is not a single isolated case the Supreme Court has seen for the last few years.
Supreme Court has criticized that governor has withhold the bills without sufficient reason. What are the constitution provisions the Supreme Court mentioned in their judgment?
Sir, Article 200, the governor is expected to act as soon as possible.
Possible, yeah. There is no
Here,
time limit.
there is no time limit, but what do you mean by as soon as possible? He acted as long as possible, as he wanted to delay as long as possible. So that is why, and apart from that, the every actions which I was telling you now, namely, he himself communicating to the President of India, he himself returning back, withholding the assent without the aid and advice of the Council of Ministers. So he himself is Sumoto writing a letter to the President of India.
There is no provisions given.
Where are the provisions? A governor is expected to act on the aid and advice of Council of Ministers. So far as the functions of the governor is concerned, he is not independent. Yes, no, he can't take decisions independently. Everything the elected representative who forms the government and the cabinet alone takes a decision, and that decision he has to scrupulously follow it, except in exceptional circumstances where I narrated to you, or under Article 356, there is a breakdown of law and order. So, therefore, all circumstances, the governor is guided with the aid and advice of the Council of Ministers. Imagine how can a governor analyze the bill? Does he have an expertise? Is he an authority? Constitution clearly says this is the only three ways for him, and he is paving out a fourth way. Can you say that I will withhold the bill? This is actually a life. This is a will of the people. What is a bill? A bill is a people's expression. Like earlier, government would have passed a bill. That time, the government, there will be a period over 5 years period will be over, or some toppling of the government happens.
Okay.
The next incoming government feels that the bill they can
It's
they
irrelevant or something like
yes,
that.
they don't want to pursue further, or they want to add something more and then bring out new bill. They will advise the governor to withhold.
Okay. Oh.
So in that event, he will withhold. He will put his seal that he is withholding the bill. But it is not as
Withholding also with assent from the assembly.
yes, from the Council of Ministers.
Ministers. Okay.
And when the bill is sent back, government present the government would feel that let us improve that bill. So they will advise him, please withhold and send it back. So he will send it back. So they will bring a new bill. But when they reenact it and send it to you, like new government comes in, reenact and send it, then you have to give assent.
Nice, sir. Sir, one side on 8th we got that order, but yet the copy is not uploaded. Another side, more than 10 universities in Tamil Nadu is headless for many years. So what next? When you will get the copy and what's next in
Sir, the
proceeding?
judgment has been pronounced in open court, sir. We can expect that. Uploading, it's only formality is uploading. Well, let's wait.
So appointment of vice chancellor, that's another big challenge before the government.
Yes,
face.
certainly, certainly.
So
This
what
is-
next in appointment of heads?
This judgment has paved a way. Now the deadlock is removed. So the governor who was supposed to, constitute the selection committee, even though he has earlier constituted a selection committee, he was not willing to participate in the deliberations of the selection committee through his nominee. And that is how the nominee was putting spokes. And in fact, the governor was acting as a road block. That is what even the Supreme Court says, don't act as a road block. You are a friend, you are a philosopher, you are a guide, and you have to act like a bridge between the government and the union government. Yet, here in this case, if you see today, we are in a situation that none of our universities are having the vice chancellors, all because of his roadblocks and the power which he wielded. One thing he forgot, the power is given by the legislature. You are not appointed through a constitution as a chancellor of a university. You are appointed through an act. Only act gives you that position as a chancellor. When the state assembly which has legislated wanted it back, what is the difficulty you have? Can you be a judge of your own cause merely because your power are going to be reduced and taken off? Can you say I will not act on that? So therefore, all his actions, in fact, are not in accordance with the constitution, and rightly the Supreme Court has set aside all the orders and passed this order.
So who will be the chancellor of university?
So far as chancellor is concerned, sir, one thing I have to clarify, sir. 10 bills doesn't deal with removing him from the post of a chancellor. He continues to be the post of chancellor, but all his powers with regard to appointment of a vice chancellor, inspection, and other things, it's been taken away. So that is what the 10 bills.
So now the chief minister actually going to have all powers in appointment of
through state
vice chancellor.
government. So that powers are there because we have to function. Universities are made out of the money given by the state government. Infrastructure is provided by the state. Appointments, salaries, and admissions all done by the university. How can the governor come, who is a nominee, and he comes here, sit inside, and he wants to control the entire universities? Something unprecedented has happened. It is happening not only in Tamil Nadu, it is happening in every state.
Kerala. Yes,
Kerala, what have you seen now? Where were you all these years? Who had run the university? One of the best universities in India is Tamil Nadu. How can you downgrade our universities? It has given a good students. Our students have gone abroad. They are shining in all walks of life. What have you seen? Suddenly you wanted to become a great savior. We have a, so therefore it is all politically motivated, and that is why the governor was acting in defiance to the constitution. You were appointed pursuant to an act, but he doesn't have a faith in those acts. You are a chancellor because of an act which created the university. You derive your power from that act. Now you would say, no, I will not act in accordance with the act.
So
I will defy that.
my understanding is the governor will continue as a vice chancellor of the universities, but the powers appointing vice chancellors in those universities, it's now laid with the state government. Right?
This is so far as the 10 bills are concerned. But now this has given a way, paved a way for the government, even for removal of the chancellor and substituting with that of the chief minister. Because if you take Gujarat, in Gujarat, the chief minister is the chancellor of the university. So therefore, of course, this every right is there, every power is there for the.
If state thinks.
Certainly, the assembly, that is what the sovereign function. Today, our leader has shown to the whole of India that the power or the sovereign functions of the assembly cannot be wilted down merely because of this governor who disobeys the constitution. This is a real landmark judgment. It is actually a path breaking judgment, and this has brought hopes in the functioning of the constitution. What the governor would have thought is, look, my eyes are closed, so the world has become dark. It is not so. Merely because you tie the bills and keep it in your cupboard, the people's will not sleep. The court, another organ is there, it will rise up and it will act. And that is how, in this case, the court has come and stepped in and has granted release. So, the constitution should work always. The constitution will not allow anybody without any remedy. That is what today, when the judgment has proved.
Thank you so much for sharing insights, sir. Thank you so much.
Thank you.